following the filing of the lawsuit, Ripple announced that it would not be viewing 2 years' worth of audited financial accounts, contracts for the sale or transfer of XRP to non-employee counterparties, or information about the amount of money the SEC received from institutional sales of XRP. The proposed XRP sales discovery request against Ripple by the U.S. Securities and Exchange Commission was therefore approved. The U.S. Securities and Exchange Commission used a late-day filing on January 23 as the basis for its informational response. According to the U.S. Securities and Exchange Commission, Ripple is thought to have provided more proof in support of its decision to compel. As the chairman of C indicates, its queries regarding possible repairs are neither premature nor outside the bounds of the authorized process. In addition, I think the Securities and Exchange Commission is trying to make a very clear point, which is that when deciding how to remedy violations of security law standards, courts usually take into account actions taken after a complaint has been made. In order to get an injunction that would halt such transactions in their tracks, this organization contends that it is not required to do so. It does not seek a mini-trial or any other assessment of the validity of sales to companies, including ODL customers, that take place following the filing of a complaint. It is just requesting that RIP be punished for violating securities laws. This is an important problem, even if there isn't a tiny trial. It involves a lot of stakes. Ripple, an online decentralized ledger startup, is likely to be subject to wide injunctions. Signed subsequent to the complaint's filing, I hope a discovery order will be issued on these contracts. The statement Ripple plans to organize them in an unconventional way is able to be made. Nonetheless, the ECC argues that Ripple should be the one with the postal and post-summary judgment contract so that it can investigate Ripple's plans and determine whether or not they are legally allowed to engage in DL sales. The SEC has submitted an application for financial records. According to a statement from Ripple's attorney, Caroline Deser, the Securities and Exchange Commission (SEC) did not file a request for discovery while the investigation was still going on. This eliminates the potential that more information concerning sales that occurred after the complaint was filed would be required. Also, the Securities and Exchange Commission has exhausted all of its interrogatories pertaining to this specific matter after submitting a request for that. Based on the evidence that she provided, Caroline Diari, a Ripple consultant from 2015 to 2019, made a public statement. 23 distinct counterparties signed XRP direct sales contracts with Ripple through XRP between July 2017 and April 2020, according to the numerous business documents that Ripple has made public. It was implied that Ripple was the one who invented XRP when she continued by saying that the majority of XRP sales that took place between May 2020 and June 2023 were transactions. The ongoing conversation around XRP was furthered by her statement that Ripple has sold XRP to customers that haven't been identified by market makers on regulated digital asset exchanges. With this document titled Reply and more support for his move to compel the SEC, its quest of complete discovery from Ripple has moved to a significant new level. The U.S. Securities and Exchange Commission and Ripple Labs have issued a comprehensive response to us, magistrate judge for the Southern District of the U.S. Sarah Nitburn, in response to Ripple's argument over the parameters of discovery, in highlighting the dynamic character of the lawsuit. The statement provides specific court records that demonstrate the consideration and eventual granting of the lengthy discovery periods. Teton, an XRP lawyer, explained how Judge Torres's approval of this strategy allowed Ethereum to get away with much more reading. According to the Securities and Exchange Commission (SEC), additional periods for discovery are under consideration. Utilizing an adaptive and iterative discovery process, the behavior was thoroughly clarified and mentioned in a court record. The main point of contention in the securities dispute is how the Complaint Revision Commission's allegations relate to Ripple's financial situation and institutional sales agreements. By emphasizing how much a defendant's wealth matters for determining fines, the Securities and Exchange Commission successfully invokes precedent to bolster its argument. When it came to choosing the proper level of punishment to discourage misuse, the Second Circuit Court of Appeals expressly rejected this approach. This is consistent with a statement released by the Securities and Exchange Commission, SEC arguing that consideration should be given to the defendant's wealth while developing its conclusion. This narrative emphasizes the document's strategic significance elucidates the significance of Ripple's institutional sales contracts that were signed after the company filed for bankruptcy, and sheds light on the business's future plans for XRP sales. State banking institutions are expected to use XRP for cross-border transactions, according to the Securities and Exchange Commission. It's likely that these contracts were overlooked in the past because the Securities and Exchange Commission (SEC) views them as historical records as well as possible predictive markers of future regulatory violations. One argument made in support of this allegation was that the precise contracts that the SEC looks for support compliance. This statement implied that any patterns or intentions that emerged from these documents would have an impact on the party's future compliance with the court's orders. The Securities and Exchange Commission, one of its two representative organizations, has stated that it would not hold a mini-trial or take any other action about the validity of sales that have been made after a complaint has been filed. A supporter of XRP and an advocate for Ripple, the General Business Counsel has stated that he thinks his client has adopted an appealing strategic pose. In contrast to what Ripple has claimed, he contends that the Securities and Exchange Commission must demonstrate to the court that a request for the discovery of contracts entered into after the complaint was filed will not lead to a mini-trial about the legality of sales that were made after the complaint was filed. Despite the possibility of a broad injunction on these contracts, which were signed after the complaint was filed, Morgan points out that Ripple, the online decentralized ledger company, is adamant in its position that it need not comply in order to circumvent the injunction that would prevent the aforementioned transactions. Moreover, the attorney has reason to think that Ripple would attempt to assert that it intends to reorganize XRP sales in the future that were previously old sales in a particular manner to avoid being included in the institutional sales group under the summary judgment. That being said, Morgan thinks the data will prevent a mini-trial from being conducted. 25 million XRP were sent in 4 separate transactions, each by 4 different BitViva wallet addresses, to various recipients at various times. With these 5 trades, the total amount of XRP exchanged soon surpassed $125 or $64, 3 cents million dollar, according to current values. The initial transaction had this outcome. 4 of the XRP whale addresses that CryptBasic is investigating are also brand new wallets that were enabled today, which is an intriguing thought. But one of them has an activation date of December 8, 2023, even though it has been there for more than a month. The last transfer occurred a long time ago. This address has not been used. It should be noted that before the delivery of the gowns, every sender obtained millions of XRP tokens ranging from 198 million to over 223 million from opaque sources, based on the sending addresses. This tendency suggests that the offender may have diverted the funds in order to obscure their identity. It is crucial to remember that market participants often make snap decisions about whether or not Ripple is responsible for these big whale changes.